This is Bloomberg Law with June Grasso from Bloomberg Radio.
Bankman-Fried and his co-conspirators stole billions of dollars from FTX customers. He used that money for his personal benefit, including to make personal investments and to cover expenses and debts of his hedge fund, Alameda Research.
And now a jury will decide whether Sam Bankman-Fried is guilty of orchestrating a scheme to bilk investors and FTX customers out of billions of dollars. In the 10 months since Manhattan U.S. Attorney Damian Williams announced the charges, prosecutors have collected millions of pages of evidence, including financial records, spreadsheets, memos, Google documents, and private communications. They've also flipped 3 of SBF's top lieutenants who will now be testifying against him. My guest is former federal prosecutor Brian Klein, a partner at Waymaker Law. Tell us about the case against Sam Bankman-Fried.
Sure. Well, there's a number of charges there, but overall, the focus is that he defrauded people who placed their money and trust into FTX. So there's a variety of different charges how they get there, but that's the center of the allegation. So that's what the trial is going to be focused on, is what happened at FTX, how that related to Alameda, which was this, as alleged, a venture arm, essentially an affiliate of FTX, and then where the money went.
Is it a mix of substantive and conspiracy charges? And, tell us what the difference is.
There's a number of charges here, including conspiracy charges, like conspiracy to commit wire fraud, as well as the underlying wire fraud charge itself. And conspiracy charges can pose some difficulties for prosecutors because often jurors innately can understand a straightforward charge like you committed wire fraud. That's the allegation. Whereas when you have a conspiracy, oftentimes the actual jury instruction can be difficult to follow and the juror can get sometimes confused. In this case, though, you have a number of his alleged co-conspirators who everyone expects to testify, former senior officials at FTX. The prosecutors, I imagine, think they're going to paint a very vivid picture of what happened here through this testimony of actual witnesses who were there when this was all going down. And so I think that's going to put a lot of meat on the bone here that sometimes isn't there. A lot of times there is a case where the alleged co-conspirators aren't available to testify for one reason or another, or actually are co-defendants and don't testify. But in this case, Sam is facing these charges alone. He'll be the one person there sitting at the table with his lawyers, and his former colleagues and former underlings will be getting on the stand, as we understand it, and testifying against him and pointing the finger at him.
3 former FTX and Alameda executives, his top lieutenants, including supposedly the star witness, is likely to be Carolyn Ellison, who ran Alameda and was in an on-again, off-again relationship with Sam Bankman-Fried. So how does the defense go after them when there are 3 of them saying the same thing?
Well, we don't know that they're all going to be saying the exact same thing. So that's one area that the defense can try to probe on cross-examination. We can expect them also to attack the credibility of each of the 3 and the fact that they pleaded guilty and are probably hoping for some benefit for their testimony. And particularly with Ms. Ellison, I think, just if we follow what Sam said about her since he's been arrested and what we've learned through the New York Times, we can expect the defense to make some issue about their relationship and, maybe try a sort of guilted lover defense, which is, she is actually responsible for things, kept him in the dark, and that she is, upset at him about how their breakup ended. That seems to be a defense they're angling for, but we won't know until she gets on the stand.
Besides those witnesses, prosecutors have apparently amassed millions of pages of evidence. The evidence includes financial records, spreadsheets, Google documents, and private communications, and notes that Ellison took after conversations with him. So they'll use that to buttress the testimony of their witnesses.
Absolutely. If you're a prosecutor, you want to try to find the, quote, independent pieces of evidence that support what the person's saying. So those could be emails that were sent contemporaneously, text messages that were sent contemporaneously, or they could be financial records that show what happened. So you're trying to buttress that person's testimony with other pieces of evidence that really can't be disputed or will be very difficult to dispute. So we can expect that to be their plan and that they'll proceed that way with her, but also with the other witnesses too. They're going to want to not just have people get up there and say things and point the finger at Sam. They're going to want people to get up there and say things and show them documents that help paint the portrait of what happened, or at least what they claim happened there. And then Sam's lawyers probably have their own documents they're going to show to the witnesses. One thing the defense does is, they try to, the legal word is impeach, undercut the testimony, and they will probably be some documents out there that maybe Ms. Ellison hasn't seen or the others haven't seen or even aware of, that they'll show to her and try to catch them off guard. These are savvy prosecutors, though, and they're expecting that. And so prosecutors often build into their examination of the witness on direct. They'll try to front some of those issues and have the witness make statements about some of the things that may be vulnerabilities to undercut that attack on the defense. So they try to get in front of the issue as much as they can without undermining the credibility of their own witness.
Before he was arrested, Sam Bankman-Fried made all kinds of statements that seemed like admissions of some of the facts here. How does the defense deal with that?
That's a real struggle for any defense lawyer if your client is making statements before charged that relate to the impending charges, or in this case, he's made statements since being charged to various people. I suspect that was not, his lawyer's advice to keep talking or to talk then, and probably went against his lawyer's advice. And there were reports that a number of lawyers has now had given him that advice and sort of withdrawn from representing him even. So that makes the defense lawyer's job just that much more difficult, because now you've got statements that are sort of immediately after the collapse of FTX. He went on various podcasts and made statements to reporters and et cetera. And then you have statements after even he's been arrested, where he's making different claims and putting forth his own sort of narrative of what happened here. And so he's really giving the prosecutors a big advantage here in terms of how they prepare their case, because now they got a whole wealth of statements. They also get a sense of where he thinks he might be raising defenses, so they can start to plan for that more. So I don't think his lawyers would have ever recommended he talk to the press or make these statements. It really only hurts their ability to try to get him acquitted.
So do prosecutors have to prove his intent, and will that be hard?
Absolutely, they have to prove his intent. This is not a drug case where it's you were in possession of a suitcase full of cocaine, which you just can't have a suitcase full of cocaine, right? The question is, did you have it? It's usually not what were you thinking when you were carrying the suitcase full of cocaine? It's self-evident. Here it's different, though. With any type of white-collar case and these type of charges, fraud charges, you have to show often specific intent. So that means that the person set out knowing what they were trying to do to defraud the person and actually did then defraud them, or at least attempted to defraud them. So that's a pretty high burden, and you have to show it by proof beyond a reasonable doubt, too. Here, though, the prosecutors have a wealth of apparent inside witnesses, the lieutenants you mentioned, as well as tens of thousands, millions of pages of documents and communications. Now, this case isn't going to be, 10,000 exhibits, hundreds of thousands of communications. That's just an overwhelming amount. Even in a case with voluminous discovery or voluminous documents seized or obtained, usually the prosecutors focus on a set of key documents or communications, and they try to show the jury as easily as possible and in a non-confusing manner what happened here. And they're going to highlight, I'm sure, certain types of statements, certain communications, and certain key documents. Even a case as this big often comes down to maybe 10 or 20 documents that are really central to the prosecution's theory, and the same number that may be central to the defense. So even though this may seem like millions and millions of pages of documents, and I'm sure it is, often these cases come down to a very discrete set of communications and documents.
He's had some pretrial setbacks, including that he's now in jail. Judge Kaplan put him in jail because of communications he made. How much more difficult does it make it if your client is in jail in the final weeks of preparation for the trial?
It's just magnitudes more difficult. Even in the months before, at any point before, it's more difficult when your client is detained leading up to trial, because you're often wanting to meet with them, talk about different pieces of evidence. And when someone's in jail, you can't just pick up the phone or send them an email or a text message or whatever. And these jails have rules about when you can meet, for how long. Now, lawyers are given a lot more leeway than just a family member or a friend trying to visit somebody, but there are still, rules and times, and they can't communicate in a certain manner. So it just makes it a lot more difficult for the defense lawyers to prepare. I suspect there are people there with him every day in the lead up to it, whether it's, more junior attorneys or paralegals, and sometimes the lead attorneys will, of course, be visiting and talking through issues with him. But then those attorneys have to leave their offices, go through security. They can't bring their phones in. They can usually only bring a laptop. It's set up in a special way that the jail permits. And so it just makes it a lot more difficult for everybody involved in preparing the defense. And the prosecutors don't have that disadvantage. They're at their offices. They're meeting with their witnesses outside. So, this was a major setback for Sam's legal defense team. I don't think there's any way to sugarcoat that.
Bankman-Fried's lawyers want to use an advice of counsel defense, and the judge hasn't decided yet whether he's going to allow them to do so. Tell us about that defense in the context of this case.
That's a defense that is often considered and rarely deployed. And the reason why is if you rely on an advice of counsel defense, and basically what you're saying is, hey, my lawyers told me this was fine. They may have been wrong ultimately, but it's not my fault because I actually went to lawyers and sought legal advice, and they gave me their legal opinion, and I, in good faith, relied on it. The difficulty with that is, that defense in general is, one, and this is the biggest hurdle, you have to disclose to your lawyer under this defense all the facts that would be relevant to them giving you their opinion. And that's usually the major hang-up. So you can't just tell them, okay, here are facts A, B, and D, and forget to tell them about C. Because if you don't tell them C, that would change their legal opinion. And so that defense is often thought about, but usually the issue is coming down to the missing factual disclosure that would allow the lawyer to render legal advice. I am skeptical that they'll raise that defense, or if they do, that it would succeed. But, I'm not inside the inner workings of the defense, of course, and don't know. But judges do want to know in advance of trial if that defense is being raised, because it creates a lot of different hurdles for the prosecution, because the prosecution will want to know kind of what's coming down the pipe. And so I think it's unlikely this defense is actually raised, but if it is, it will make for a much more interesting trial. It's already an interesting trial.
The judge has ruled that SBF can't call 7 expert witnesses he wanted to call, though he left the door open to call, I think, 2 in response to the government's witnesses, perhaps. What do you think about the judge just ruling out these witnesses?
I think judges are fine, and trials often involve a battle of experts. So the defense will put on some experts, and the prosecution will put on some experts. And they'll be talking about the same things, and then it's up to the jury to decide whose testimony they want to credit of those experts. What they don't want is a lot of duplicative experts, a bunch of experts on one side all saying the exact same thing, so that it feels like, well, we have 6 experts say this and you only have 2. And so that's not really what they're looking for. And so I think judges like to narrow down the number of experts to make sure that they're touching on the same issues and not being duplicative. Also, there's sometimes areas that aren't really the subject of expert testimony. Both the prosecutors and the defense may try to call somebody, and actually it's really a factual issue. So the judge instructs on the law, and the jury decides the facts. And the experts can offer an opinion in a specialized area for the jurors to consider. But they can't tell the jurors ultimately, like, this means this, right? Like, you should assume based on this set of facts that there is no way this person couldn't have the intent to do this. They can't go to the ultimate issue. That's what it's called. That's up for the jury. So this judge is a very sophisticated, smart, seasoned judge who was known to run a tight ship. And it's not surprising to me that he would rule in a way to try to keep the trial moving along and eliminate some of the experts.
I mean, besides possibly advice of counsel, what do you think might be his defense?
Well, it seems to be his defense is that he was out of the loop, that things were happening, that he was busy doing certain things, and that other things behind the scenes people were doing either without his permission or knowledge. Now, we won't know until opening statements how he's going to present his defense, but that seems to be the angle they are, if you tease out things from the defense filings, the way they're going. And it may be the added layer of not only did he not know exactly what was going on, but the things he did know that were going on, he had sought legal advice for and thought they were fine. That appears to be the direction his defense is headed. But we really won't know, and they may pivot or expand or narrow the scope of the defense. So we really won't know until opening statements. And we frankly may not even know until his closing statement, because the government has the burden of proof. And, they're going to put on a very thorough opening statement that explains their case and why they think, Sam committed these crimes and that they can prove that and meet all the elements of the charges. Sometimes the defense puts on a much more higher level opening statement that asks the jurors to, for example, pay attention to the evidence, keep an open mind, reminds the jury that the defendant, is innocent until proven guilty, and the high burden the government has to meet here, proof beyond a reasonable doubt. That seems less likely in this case. The case has obviously gotten a lot of attention, and I think when you're talking about the billions of dollars at issue here, the sheer number of things that went on here, I think the defense is going to offer a pretty robust opening statement.
Do you think that Sam Bankman-Fried will take the stand?
I think that's more of a possibility here than is regularly the case. Ultimately, that is not his lawyer's decision. That's his decision. Based on his talks with the media, his vocal personality on social media, and sort of his need to stay in the limelight here, I would be surprised if he didn't take the stand, but I think it's possible he won't, because it is very unusual. I haven't looked at a study on it, but I bet at least 90% of the time the defendant does not get on the stand. But here I would put the odds at least 50-50 that he gets on the stand. And that's just because of the way his personality. He seems like the type of person that wants to get up there and give his version of events. I think if he does do that, you're going to have days of testimony here. And it could be very similar to what happened in the Theranos trial with Elizabeth Holmes, where she got on the stand, tried to convince the jury of her version of events, obviously unsuccessfully.
Is this a case where it would be difficult to find a jury?
No. I mean, every case you can get a jury, right? Even in the most high-profile cases in the United States throughout, the last, 50 years, they've been able to find juries. It's going to take some time here because obviously this case has gotten so much attention, and a number of people probably do have preconceived notions about his guilt or innocence. Most likely, I would guess they have preconceived notions that he's guilty. And so I think it will take some time, at least a few days, to get a jury selected. This judge, these lawyers will work their way through the prospective jurors and find them. I think they're going to call a large group of people, though, well over 100, I would guess, as a pool of jurors to work their way through. But ultimately, even knowing about a case doesn't preclude you from being a juror. The real test is, are you willing to be fair and impartial? That's what the judge is going to be looking for, is to see, 12 fair and impartial jurors.
Jurors who can sit for the up to 6 weeks the trial is expected to take. Thanks so much for being on the show, Brian. That's Brian Klein, a partner at Waymaker Law. Coming up next on the Bloomberg Law Show, what happens when jury deliberations descend into chaos? I'm June Grasso, and you're listening to Bloomberg. An Atlanta trial threatened to descend into chaos after jurors clashed over race and class while weighing charges against a wealthy developer and 2 others accused of arranging $1.3 billion in phony tax deductions. Problems began to emerge soon after the jurors began deliberating last week and deteriorated into acrimony, causing jurors to complain to the judge. Federal Judge Timothy Batten then interviewed jurors in open court and in his chambers, met with lawyers, and finally, after a change of heart, dismissed 1 juror. My guest is Bloomberg legal reporter David Voreacos. David, tell us what this trial was about.
Jack Fisher is a developer and accountant who was on trial for selling tax deductions to wealthy taxpayers in exchange for investments in group financing known as syndicated conservation easements. Now, this is an arrangement that the IRS hates and has been cracking down on. And essentially, what happened was partnerships would promise that they would not develop land, and in return, the investors would get inflated tax deductions according to the IRS. And those tax deductions in the Jack Fisher case relied on inflated appraisals and on backdated documents. The IRS had been investigating this process for several years, and Jack Fisher was the first promoter of syndicated conservation easements to be indicted. He went to trial in Atlanta over the summer, and his trial lasted 9 weeks.
Jury deliberations are secret. How did you find out that there was trouble in the jury room?
The jurors themselves complained to the judge that one of the jurors, who was referred to in court papers as Juror 26, was refusing to deliberate. And that juror walked out of the deliberation room and went upstairs in the courthouse. Now, jurors are not supposed to deliberate unless all 12 are together at the same time in the same room. So without her in the room, they could not deliberate what was a very complicated fraud case that involved dozens of charges against Jack Fisher and 2 other defendants.
There were no racial aspects of the trial, but racist comments were made in the jury room.
That's correct. This was a pure financial trial that turned on complicated testimony about partnerships and about tax deductions. And so what happened was the judge on Monday of last week decided that he would interview several of the jurors in chambers. And this is very unusual because during jury deliberations, it's considered a sacrosanct process that no one is supposed to know what goes on. So what came out as a result of those interviews by the judge was that one of the jurors, juror number 26, who's white, said that another juror, juror 44, who is black, had said weeks earlier that he would convict these defendants because they're rich, white, and entitled. And then juror 26, again, who's white, said that she felt that she was standing up for white people during the deliberations. And this she said in the privacy of the judge's chambers. However, it was transcribed so the other lawyers could see it, and then they put essentially that exchange in court filings, which is how I was able to see it. Now, this then escalated into a very tense and emotional conflict in which the Justice Department moved to dismiss Juror 26 based on her comments about standing up for white people. And they also said that if, in fact, Juror number 44 had said that he was going to base his verdict on whether the defendants were rich, white, and entitled, that he should be dismissed as well. So what happened was that last Monday, the judge said that he would not dismiss the jurors and that he would urge them to continue deliberating. And then on Wednesday of last week, the judge said that he had reconsidered and that he was going to dismiss Juror 26 because of her comments and because he concluded that she was still not deliberating.
So I assume that the defense objected to removing Juror 26, who seemed to be leaning in favor of their client.
Yes, she had made clear that she was leaning toward acquittal, and they said that it's improper under the procedure set up in a Supreme Court decision on removing a juror for racial animus. And they essentially said that the jury deliberations were no longer deadlocked as they had been earlier, or stalled because she wouldn't deliberate, because the jury had indicated that they had reached a verdict on 8 or 9 of the dozens of charges. But the judge ignored that and said that the other considerations were so powerful that he was left with no choice but to remove that juror.
Did anything happen between Monday and Wednesday that made him, or Tuesday and Wednesday, that made him change his mind?
He said that he was anguishing over this and had given it a lot of thought, and it essentially didn't sit right with him. And so that's why he was reconsidering and did it, as they say, sua sponte, which is on his own without anyone requesting him to do that.
So then how did it work after that?
After that, he replaced that juror with another juror who happened to be black, and this was a predominantly black jury to begin with. They then deliberated 2 days, and on Friday of last week, they found Jack Fisher and one of his co-defendants, Jim Sinnott, who's a lawyer, guilty of all the charges. They also acquitted Clay Weibel, who was a real estate appraiser and was charged with being part of the scheme.
So I assume that the defense is going to appeal based on the judge removing this juror.
The defense indicated in the many motions that were filed last week that that's exactly what they were going to do.
It sounds like a good issue for appeal.
It's clearly a very sensitive and fraught issue that's been litigated in the courts, and part of what the defense was doing is they were trying to lay down a clear record for the appeals courts.
Yeah, because, I mean, as you mentioned, it's so rare that a juror is dismissed from a trial in the middle of deliberations. I mean, it's incredibly rare.
It's quite unusual, and in this case, the defense felt it was really unfair to them and to their clients' rights. And one of the reasons that the judge delayed so much is that he made plain several times that he's trying to protect the rights of the defendants in this case.
And the kind of deal involved in this case is something the IRS has been going after?
The IRS for several years now has been going after promoters of this type of investment, again called syndicated conservation easements, because they believe that while the practice of donating conservation easements is allowed by Congress, the reality of the way it was carried out in syndicates like this one abused the letter and spirit of the law and was essentially robbing the U.S. Treasury of tax revenue that it deserved.
You're going to stay with me, David, and coming up, we're going to discuss New Jersey Senator Bob Menendez's first news conference since his indictment on corruption charges. This is Bloomberg.
I firmly believe that when all the facts are presented, not only will I be exonerated, but I still will be the New Jersey's senior senator. To those who have rushed to judgment, you have done so based on a limited set of facts framed by the prosecution.
Today, New Jersey Senator Bob Menendez held his first news conference since his criminal indictment on corruption charges, rebuffing calls for him to resign and saying he'll be exonerated. Prosecutors allege that Menendez accepted gifts, including a luxury car, gold, and hundreds of thousands of dollars in cash, in exchange for using his influence to bolster U.S. assistance to Egypt and to benefit 3 New Jersey businessmen. I've been talking to Bloomberg legal reporter David Voreacos. David, tell us about the charges.
Federal prosecutors unsealed an indictment on Friday that charged him, his wife, and 3 New Jersey businessmen in a bribery conspiracy. This came after U.S. authorities had raided the senator's house where he lived with his wife in Englewood Cliffs, New Jersey, and found nearly $500,000 in cash that was in envelopes, that was in his closet, that was in a safe. They found tens of thousands of dollars more in cash in a safe deposit box for his wife. And what they said was that the senator had engaged in several conspiracies to help the government of Egypt and to help these 3 businessmen in their various legal disputes, one of whom was facing indictment in New Jersey, and the other one had an associate who was under indictment in New Jersey. So they asked the senator to help them to use his influence in all of these cases. What's quite shocking in this case is the amount of cash as well as gold bars that were found in the senator's home. So on Monday, Menendez resisted a number of calls that came over the weekend for his resignation, including by the New Jersey Governor Murphy, by several representatives in Congress from New Jersey, and he said quite defiantly on Monday that he was not resigning, that he was going to fight the charges in court, that he was not guilty.
He also gave an explanation for the cash.
Right. He is the son of Cuban immigrants, and he grew up in Union City, New Jersey, which is a heavily Cuban community. He had been the mayor there. He'd been an elected official representing Union City. And his press conference was in Union City at a community college. And he said that because of his family's experience in Cuba, where they feared confiscation of money by the government, that he had been in the regular habit over the past 30 years of withdrawing cash that he legally earned.
Did he say anything about the gold bars?
He did not mention the gold bars. He also didn't mention the Mercedes that prosecutors said one of the co-defendants used to bribe him.
What happens next in this case?
The senator, his wife, and the 3 New Jersey businessmen will make an initial appearance on Wednesday in federal court in Manhattan. It's expected that they would all enter not guilty pleas, assuming they're arraigned, and the judge would then probably set a calendar for motions and future hearings. He may set a trial date.
And remind us about Menendez's last trial.
Senator Menendez was indicted in 2015 in a different bribery case involving a Florida physician. He went to trial in 2017 in federal court in Newark, New Jersey, where the jury deadlocked and the judge declared a hung jury, and the Justice Department later dismissed the case rather than bringing it again. Menendez was reelected in 2018, and now he's up for reelection again in 2024, but he hasn't said since his indictment whether he intends to run for reelection or not.
Thanks so much for being on the show, David. That's Bloomberg legal reporter David Voreacos. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.